Good morning, Madam Deputy Registrar. Would you mind commencing proceedings, please?
Good morning. Thank you, Judge. Caribbean Court of Justice, Appellate Jurisdiction. An appeal from the Court of Appeal of Belize, monitoring hearing in CCJ Appeal BZCV number 2 of 2014 between the Maya Leaders Alliance and 23 other villages and the Attorney General of Belize. The members of this morning's panel are Mr. Justice Anderson, presiding judge.
Good morning, Counsel.
Madam Justice Rajnas Lee.
Good morning, everyone.
And Madam Justice Onaniwu.
Good morning, everyone.
May we have the appearances, please? Thank you.
May it please your honors. Nigel Hughes with Miss Leslie Mendez and Mr. Alistair Jenkins. I haven't appeared before you for the year, so may I take the opportunity on the penultimate day of the year to wish the entire panel the very best. And I haven't appeared before the new Madam Justice. May I offer the congratulations of my entire team.
Thank you, Mr. Hughes.
Thank you, Mr. Hughes.
Yes. Good morning, Your Honors. May it please Your Honors, I, Andrew Marshall, together with Mrs. Samantha Tucker, appear for the respondent.
Thank you, Mr. Marshall. Thank you, Counsel, for your appearances. And as indicated by Mr. Hughes, we have a new panel this morning. Our president, Justice Saunders, has asked to be excused on this occasion, and instead, as indicated, we have a new member, or the newest member for bench, Justice Chantel Naniwu, who is with us. Justice Naniwu is an expert in many areas, including international law, and I'm sure her expertise in guiding us over the last hurdles will be very much appreciated. Thank you. Are there any other appearances to be entered? In particular, is the authority here? No? Okay, well, we will proceed. As you will know, we are hopefully coming to the end of a fairly long process. I can see that from the compliance reports we have been making progress, uneven progress, but progress. And I think we'll be making progress in relation to some of the more intractable, more difficult problems. I do note, of course, the issue of consultation, which no doubt the appellants will speak about in a short while. I am proposing that we examine a series of issues seriatim, and therefore, after a very brief opening statement on both sides in terms of your assessment as to where we are, very, very brief, I'm going to propose that we look at the following items, and we have your views on each of them before moving on to the next. So the first item would be the Maya land tenure policy. Then number 2 would be auto delimitation. And then we have a group of issues dealing with the FPIC, the protocol. There is a Santa Ana Village project. There is the FOB. And then there is the Golden Stream shall we say, incident. We then want to look very briefly at the report from the point of view of the IACHR as reported by the appellants. And then the revised roadmap. And then finally, the arrangements for our next meeting. Unless there's anybody who objects strenuously to that way of proceeding, I would invite the parties to make a very, very brief opening statement, which is meant simply to give an overview as to where we are now, particularly in relation to where we were on the last occasion that we met. And I'm anticipating a minute or two or three should be sufficient. Appellants?
Yes, Your Honors, may it please you. Your Honors, can Your Honors hear me well?
Yes, very well.
Yes. May it please Your Honors, and a Happy New Year to everyone, and welcome, Madam Justice Chantal. It's a pleasure to have you here. I wish that the report was a bit more positive, Your Honors, but as you have seen in our compliance report, from our vantage point, there really has been not much progress since the last hearing that we were before the court. There has been no discussions, meaningful or otherwise, between the parties. At the last hearing, Your Honors would recall that there were some indication from my learned senior, in fact, that with respect to the revised roadmap, we would still have some room to have further discussions, specifically at the session with the Inter-American Commission of Human Rights that was scheduled to happen in October. There was also a commitment to share the revised policy, Your Honor. Unfortunately, at the Inter-American Commission, the respondents participated only via observers who could not engage meaningfully. One, because they didn't have instructions to do so, and two, because they were, I think we can fairly call them strangers to this process. As well, there was no opportunity to speak about the revised policy because the revised policy was not shared with us. In our view as well, the compliance report, which we hoped would have given us a bit more insight as to precisely where we are with that policy, does not assist either. In our view, some of the statements that are made are quite contradictory. So for instance, at one point, it says that the revised policy has been approved and has been finalized, and on the other, it says that it hasn't. So our fear, and in fact, from what we are seeing, is that there appears to be some sort of a rollout or an approach, a strategy of non-engagement with the appellants currently. We have asked for updates, and we have not even received an acknowledgement of receipt even of that email. There's no indication even in the report that the policy will be shared with us. And to be quite frank, I don't know what accounts for this. I think that the appellants before this court throughout these 10 years, and certainly I can speak for the nearing 5 years that I have been before the court, we have had several moments, but I think that certainly we can say that we have tried our best to devise ways in which to meaningfully and collaboratively engage with the respondents. And last year, we thought that we were in a good moment in May when we had a meeting. But after that, Your Honors, there has been simply no engagement. That draws us to, as well, I agree with Your Honor. I won't be long, but I do want to mention with respect to the issue of Golden Stream. The issue of Golden Stream, I think, also is an example.
Sorry. Yes, with respect, would you mind if we reserve that discussion until we get to that item? I think we have the overall sense of the point that you're making in relation to your view that there has not been adequate, indeed any, consultation with you. A respondent?
Yes, thank you, Your Honor. With regard to the first item, the policy, Your Honors will remember that there was a compliance hearing in October last year. The correspondences that my friend pointed to as the last items of communication between the party are dated in June and May. So that we were here, we did inform of what positions were, on which Your Honor's participation had a clear communication as to what that was. But I can remind the court what it was then and what it is now fairly quickly. You will recall there were face-to-face meetings in May, and then subsequent to those meetings, a letter was received from the appellant setting out what they say their position is. The comments on the policy were. A number of those comments were that their positions remain unchanged from what they were before the discussion started. The communication was a clear indication that the sides were crystallized in their position so far as the policy was concerned. And even in terms of the matters raised in that letter, what they had sought to do was to get into the details of resolution of disputes with third parties and mechanisms for doing it, which was not within the policy, but would need to be dealt with as a part of the development of legislation. We took the comments and the policy, a copy of which they have, the same one we discussed in May, and we made a presentation to Cabinet for its consideration and approval and of the policy, as we indicated we would. In fact, I think we had already made that presentation, or we made it just about the same time of the last compliance hearing in October. What came out of that was that the policy was approved, subject to 4 concerns they wish addressed. We addressed those concerns by incorporating proposals for changes to the draft and resubmitted the draft policy on October 17 for final approval. And that's where it sits. We expect that the silence on it is really that there is no issue with it and it will be approved as a course. We also made an attempt to, well, I don't know if you want me to go forward because it does touch on concern delimitation, but the approach we took in the interim, and I think monumental achievements have been made, was to seek to flesh out the policy and produce a working draft legislation, which we have done.
Yes. Mr. Marshall, if you don't mind, sorry, we wanted to sort of separate out the policy from the auto delimitation, which will be the next item. Did you want to say anything further about the policy?
No, that's the status of the policy. It was revised to address the 4 concerns that were expressed by full cabinet, and the draft was resubmitted to the cabinet subcommittee for approval. It is
and that was on the 17th of October.
That was on the 17th of October, according to my records, yes.
Yes. When would you, in the natural course of things, expect to get a formal response?
Well, I chased that up to yesterday, and I'm told that the amendments to the policy and the working draft of legislation will both be submitted to the subcommittee at the cabinet meeting next Tuesday.
What date is that, please?
You're on the next Tuesday is the 4th.
The 4th. Thank you. The 4th.
4th of February, yes.
Yes.
Of course, I know that you are aware, Mr. Marshall, as we all are, that we are working against the clock. So I'm sure you'd have conveyed that in your communications to the cabinet and the subcommittee of the cabinet. Yes.
And this is, Your Honor,
Yes.
this is precisely why we push matters further, because we can't be stuck in the policy forever. And the discussions on the policy are moving into the kind of details that's more appropriate for discussion in the draft legislation itself. So we took the initiative and the step of preparing that draft, which will not only allow us to flesh out and for cabinet to properly appreciate the implications of the policy in more detail, but will allow for a quicker technical review by the draftsperson when they get their hands on it.
Well, assuming.
Yes, sorry.
Assuming, please go ahead. Yes.
Sorry, I thought we were better positioned to do that, given that we were involved in all the discussions and all the consultations over the many months, rather than somebody starting anew, trying to develop these concepts. So we've developed the concepts. Of course, technical drafting, formatting, and the rest of it needs to be done, and cabinet needs to sign off on it before we make it available to the other side.
Mr. Marshak, if I may, through you, just to answer. Yes, Mr. Marshak, you have engaged that legal draftsman then that you spoke about, and that is the working draft that you're speaking about has been prepared by that person?
No, we made an attempt at engagement. It wasn't successful. We prepared a draft as part of the instructions to the draftsperson. But it's to set out the concepts and the details and provide more details than the policy as to what is expected in the draft, so that the process of actually drafting and making it technically correct is moved in the interim. We didn't want to delay it any further, given the timelines that the court indicated that they wanted a draft legislation prepared. So it gives us something to work with and something to discuss with the other side in a more meaningful way, rather than being stuck at the policy level on a few items.
So does it still have to go to that legal draftsman, or is it simply, because I think you mentioned that it would need formatting and so on, I'm not sure.
Yes, it needs a technical review by the draft person to improve for clarity and that type of thing. So it will still go before it reaches a form that we're used to seeing it in.
So this gets to the draftsperson. Let's be gender neutral if we can.
Yeah.
On or around the 4th of February. Best case scenario.
It gets to cabinet for their sign off on it. And then that it's an accurate reflection of their instructions to the draftsperson.
Oh, so you're hoping it will get to cabinet on the 4th of February?
Yes, it will be presented. I don't know that a decision will be taken on that day, but they start their deliberation on it. And I'm hoping for a quick decision on it, given that it largely reflects the policy and addresses the 4 concerns that they raised in relation to the policy in more detail.
Do you have an advocate in the cabinet who would make clear those points?
Historically, I have attended and made presentations.
I was hoping that would be the case.
I haven't been asked to do so yet, but we are certainly available to do so. We've done so in the past on at least 2 or 3 occasions.
And you will make your availability known, of course.
Of course.
Yes.
We're available. This matter is a priority for us. We don't like coming here with nothing to report. And that's why I thought that or indication that there is in hand a draft legislation, some 104 section 10 parts, some 24 pages, single space, that progress has been made. Now I understand from the appellant's perspective, they haven't seen it yet. And that is so, but we expect to get it to them as soon as the government side is comfortable with it, because there's no point in creating the kind of reaction we expect it to create when even the government side isn't set on it one way or the other.
Yes.
It's just like what happened with the policy. We expect that there will be many views expressed on it, and this is a starting point for those views to start crystallizing. But the process is, from our perspective, is that we're not authorized to release it until they've reviewed it and said it's okay, let's go, it reflects what we think we want to do. And that's the approach we've taken in the interim. So that has been achieved.
We're following you very closely, Mr. Marshall, and we obviously will have to go back to the appellants for a reaction. But what I'm trying to get from you is some sort of rough timeline. So it goes to cabinet, let's say on or around the 4th of February. I know you don't control the timetable from there on, but give us your best estimate, assuming that you were able to impress upon cabinet the urgency, given that they have approved much of it before. Again, we're not holding you to it, but give us your best estimate as to when it leaves Parliament, the cabinet, when it leaves Parliament, the cabinet, I'm sorry, it then goes to the drafts person. So one of the questions I want you to consider is there an avenue for intervention at that point by the appellants? So it goes to the drafts person, and the drafts person then puts in a very rough legal draft as to what this will look like. When is that likely, and is it at that point that the intervention by the appellants would be helpful or would be possible in your view?
Yes, that is the point at which it gets back on track with the roadmap, because we're off rails as things stand. At that point, the draft goes to the review committee, which is comprised, as we had agreed, and the schedule is adjusted so that those reviews and participation can take place. We have provided drafts of the roadmaps and provided timelines before, and as your honors would recognize, they hardly ever met, because they are really based on what we would like to see, how we would like to see it progress. And oftentimes it doesn't progress in that fashion because it's not something that's entirely within our control. So I can make best guesses, for your honor.
Yes.
But it's really not something I control. And there's a strong possibility, I suspect, that it might be overtaken by other things in the near future.
Oh dear.
Yes. I don't want to signal that there's any decision in the government or that I know anything at which I don't. But
yes.
There is,
and of course, and we know even less than you do. So we're just apprehensive of anything happening. Yeah.
Yes. Now there is a movement towards general election.
Yeah.
And I'm afraid that if I set schedules and they set schedules that don't match, this gets pushed. Well, doesn't get the priority it deserves.
Well, you're still not responding to me, though, you know. I mean, I'm asking you, and with all the caveats, best guess and all that, when does it leave cabinet and receive the attention of the drafts person so it can then go to the review committee?
I would hope within the next 30 days.
30 days. 30 days from now or from the 4th of February?
From the 4th of February. I was giving the subcommittee 30 days to review the drafts and to indicate whether they're in agreement with it or what they want done with it.
So you're saying by the 4th of March?
By the 4th of March, I don't think.
The review committee should approve. Now, let's assume it goes to the review committee. Just to be clear, is that the point at which you're anticipating that the appellants would have an opportunity to comment and make their contribution? Or are they part of the review committee?
How I see it, they're part of the review committee, but it has to come through the cabinet subcommittee, gives its green light. It goes to the drafts person, it's put in the form and reviewed for technical correctness.
Yes.
and then it's presented to the review committee as a bill in the forms bills are normally received.
So we have missed a step. I want to find out how long you think that process will take.
I am saying 30 days for them to finally get an approval of the draft and the policy, and the draftsperson's review. I think it depends on the draft. I think it can be done within 30 days too, once that's settled, and then it goes to the review panel.
So,
and that's my best guess.
No, we understand that you're not committing. It's the best guess, but it's 30 days from the 4th of February for the legal draftsman to do his work.
Yes.
And then it goes to the review committee.
Yes.
Okay. So
I'm sorry, Chair. Sorry,
yes.
Mr. Marshak, I thought you had told us originally another 30 days before it leaves cabinet. So it leaves cabinet on the 4th of March.
Yes.
Yes, and then to the drafts person and leaving the draft person on the 4th of April then?
Yes.
Well, so which comes first, the review committee's work and then the drafts person, or the drafts person then the review committee's work?
The drafts person is to produce the first draft of legislation that is to be reviewed by the review committee.
Right.
We have what I have called now a working draft. So I hope that we've caught the substance of everything that needs to go in, and the draft person then verifies that is so and puts it in the form that we're used to seeing it.
Yes.
Yeah. Mr. Marshak, did I hear you say that that copy of that working draft would be shared with the appellants at an appropriate stage? I don't recall now what stage that would be.
Yes, I anticipate that once it's approved by the cabinet and we send the instructions to the drafts person, I will copy those instructions together with supporting material to the other side. But I don't want to share it at this stage because it hasn't yet been approved from this side. And any fights, any engagements on it might be premature.
So if my math is correct, that date we're targeting would be the 4th of March. Am I right?
Yes.
Yeah. So on the 4th of March, again, subject to the caveats you have entered, the draft policy and the draft will be shared with the drafts person, copied to the appellants. And then around the 4th of April, the review committee will convene in full to review the work which has been done.
Yes.
Yeah?
That's the order, but I think that comes to about 4th May.
Comes to the 4th of May?
Mrs. Tucker is showing me here. We go 4th February to 4th March for Cabinet Subcommittee.
Right.
4th March to 4th April for drafts person.
Right. Oh, I see. Yes.
Yes. Then the review committee gets it by the beginning of May, assuming she needs 30 days to finish it, to finish whatever she'll do.
Committee. And the appellants are represented on that review committee.
And then everything else continues as we have agreed. It puts it back on track.
Puts it back on track. But the track runs out on what's the date in April? The date in which we gave judgment in April. So we really want, if at all possible, I know it's obviously in the end in the hands of the government, but we would really want the bill to be introduced into the legislature before that date. That is a critical point. Sorry, my sister.
Yeah.
I understand that, Jonah, but I'm not sure that we'll be able to meet that. But certainly a draft of it can be circulated at that point.
Are you thinking of elections again or something else?
No, I'm thinking about my friends' reactions to it. I'm sure they'll have a lot to say about it.
Well, they may or may they not. You may be surprised that they're quite, comfortable. Yes, can we hear from the appellants, Mr. Hughes, on this timetable?
Chair, before you do that, one last question, Mr. Marshall, on this. Mr. Marshall, did we hear at some stage, perhaps last year, that you spoke about other people having a say, being consulted on this bill, or will this bill simply go for the appellants to review and have a look at? I'm interested to know because it might affect our timetable. Not that I wanted to, Chair, I'm sorry to have to raise it, but it was mentioned about something about public consultations because other persons may be interested in.
Yes, we anticipate that once the bill is tabled in Parliament, it goes through its normal courses, which involve wider public consultation at that point. So we look at the review committee as the specific consultation with the appellants, which happens first. And then once the bill is tabled, we go to wider consultations in the usual course.
Thank you, Mr. Marshall.
Yes. Is there a response from the appellants?
I defer to Ms. Mendez, who would have more specific and relevant reactions.
Thank you. Ms. Mendez, I think I got your name correctly this time. You're on mute. You're muted, sorry. You are on mute. We are waiting for your reaction if you have one.
Judge, I think she's having some challenges. Ms. Mendez, are you hearing us from the Caribbean Court of Justice? But we are not hearing you. You are hearing us. Give us a sign. Give us a wave of the hand. Shake of the head. Yes. Mm-hmm. So there is a challenge. Is it something that you would?
Hi. Hello.
Great. Beautiful.
Hello.
Justice Anderson.
My apologies, Your Honors. My apologies. I was having some difficulties, technical difficulties. But with respect to what is being proposed, Your Honors, I think I'm unclear. First, I'm unclear as to whether there are any differences that are being made with respect to when these documents will be shared. Is the policy and the law now being taken as a bundle? My understanding, and I might be misunderstanding, that the policy itself is approved, but what will now go to the subcommittee is now the the working draft of the legislation, and that will then be approved and sent to us with the policy, because I'm struggling to understand why is it that we can't get a copy of the policy as yet, if it is that it's approved. And I'm here I just want to say I'm also at a disadvantage. I'm not sure why these proposals couldn't be set out in the compliance report, Your Honors. But from my understanding now is that it's the policy and the law and the working draft that my learned friends or that the respondents are a bit reluctant to share. Both documents they're reluctant to share?
Yes, I don't want to speak at all, and I can't. But please correct me if I'm wrong, Mr. Marshallek. I gather your proposal is that the policy needs to go back to Cabinet for its full and complete approval. It was approved in a sense in principle, but there were 4 points that needed to be ironed out. So it's going back to get that approval. And at the same time, to make sure we don't lose too much time, there's also going to be developed alongside that the draft legislation to give effect to the policy. Did I understand you correctly?
Yes, Your Honor, that is exactly correct. And the reason why I haven't shared them is neither is finally approved, but the copy of the draft immediately before the changes, before items raised that are subject to approval. My friend is in possession of that draft. The 4 items are relatively there's one that I think was critical, and it concerned the area to be automatically, the size of the area to be automatically recognized. But the thrust of it is essentially what they're fully aware of. There are some changes of expression that has been sought, and some minor changes which we've sought approval for before I say exactly what they are. But I'm just trying to give my friend an indication so that they're aware of what the policy looks like is largely what they have.
Yes.
The 4 changes aren't going to change the concepts in it very much.
Thank you. Does that help, Ms. Mendez?
So may I ask for a point of clarification then? At the last compliance hearing, the respondents reported that there was now a complete different approach, well, not a complete different approach, but a different approach to that section, which was now going to be assessed by the population and a specific number of acres. That's not what's there now, because that's the policy. The policy that we have is an old one. Apologies, Your Honor. Currently, it's kind of a bit like shadow boxing, because I'm not sure where we are when it comes to that.
Yes, and I think that particular issue might be the fault of the court in terms of how we are proposing to go through the items. So that particular item about the delimitation, I think we will just defer to the next discussion. Might not work very well, but what I'm just trying to get from you is, subject to that discussion, the timetable outlined by the respondent. How do you respond to that? You're muted once more.
Apologies. For us to get the policy and the legislation on the 4th, Your Honor, I think that is realistic, and we do hope that we get it on that date. We would want to have an opportunity to influence, however, Your Honor, to shape the way in which the legislation will now be drafted, as opposed to only be included at the time for now to review it under the review panel. So we would put on the table for us to have some sort of role in order to influence or provide feedback to that initial first working draft that is going to be submitted to the legal drafts person.
Mr. Marshallek, is that available? That possible?
Your Honor, we have to start somewhere. The consultations have to start somewhere at some point, and we have to at least have a position on the government side to offer the next side to consider for their consideration and discussion. We're trying to settle what those terms are on this side so that we can present them and they can have a full say on it. As to, there is no law at present. I call it a working draft. What it is it fleshes out and put tools on the bones of the policy, because a lot of the concerns being expressed in relation to the policy requires some more detail.
Yes, I'm really sorry, Mr. Marshallek. As you know, I wouldn't want to interrupt you, but I think what counsel on the other side is just asking is whether there have been opportunity for the appellants to make interventions from the point at which you copy them, the policy and instructions and so on, going to the drafts person. And all I'm asking you is whether that opportunity exists. The effect that it will have, of course, on the actual draft would be a matter for, first of all, consultations, and then secondly, but ultimately for you. But the question is whether the opportunity exists for them to make comments at that point, which should be, by my calendar, on the 4th of April.
On the 4th April, they received the document, so they will be seeing it for the first time.
Right.
I would expect they need some time to study it and to offer views, and that the opportunity for that comes in the structure of the review panel. I don't know that we want to interpose another step in between. That only pushes everything even further back.
We understand you.
You do get a full opportunity to say whatever you want to say in relation to it. And it's not that I call it a bill. Maybe we should find a different term for the document. It's just a working draft, is what it is.
Yes.
So
I think that
clarifies it.
Yeah, that clarifies it very well. Ms. Mendez, how is that? So you will have a chance to look at the document as from, again, we understand the circumstances under which these proposed deadlines are being given, but from, say, the 4th of April, you will have a chance, and then, of course, you participate in the review committee, and at that stage, you can then make whatever proposals you wish. Is that acceptable?
Your Honor, just to be clear, what we are proposing is that once we get the documents, that we simply have an opportunity perhaps to even provide it in writing, but our reaction to this working document, if we want to call it in that way, because those are the instructions to the draftsperson. So at that point, even if we just have an opportunity to also provide anything that might jump out at us or to provide more context to what is being proposed, in a way of anticipating now as well to have the benefit from the draftsperson, who's also a technical person, to see how that expert now engages with our positions. Now, that would be before the review panel. Certainly at the review panel, we will now have equal representation on the review panel, as I understand it, and we're hoping that that's still what is being accepted and agreed to. But it simply is in a way for us to participate at the earliest juncture, so that some of these things that we find problematic are not crystallized and then cast in stone, because that is what we now have to, it will now be a hurdle that we will have to overcome, as opposed to something that perhaps we might engage at its earliest opportunity to see if there is some middle ground. That's what is being proposed.
I understand. So as soon as you receive the document and you've had a chance to read through it, to consider it, to consult, if you have issues that you wish to bring to the attention of the government, you want to be able to do so, even if it is in writing. Is that what I'm hearing?
Right.
Yes, that does not seem particularly objectionable to me, Mr. Marshall. How about to you?
Your Honor, the experience with the policy is that we get locked in a loop. And I'm trying to break out of that loop through this mechanism. And I don't want to be caught in the same loop at the next step and no forward progress made, or no real forward progress made on the real issue. So as to
but
the
can't you treat with any correspondence which comes from the appellants in a way which does not inhibit your progress? All they're asking for is an opportunity to send in any kind of written comments they may have.
We'll be happy to receive it.
Thank you. Okay, so I think that settles that. So we have a rough timetable, and again, Mr. Marshallek is doing his best to give us timelines. We're really hoping that he will encourage the government to stick with the timelines. We know he will, but we obviously can't hold him in contempt if there's some slippage. But I know he'll use his best endeavors to do that. If there's nothing further on this, we want to move on to... Yes, please.
Your Honor, I would like to perhaps, I know it's not to gain necessarily clarity, because these timelines are not set in stone. But at the last hearing, I thought that what I understood the court's posture to be is that perhaps now what we're talking about is a timeline that is looking at the 10th year anniversary of this decision from the perspective of the decision of the court, so October, and not necessarily April. The reason I bring that up, Your Honor, is that we are all interested in having this order implemented, absolutely, but we're facing a bit of, as well, in tandem with that, a sort of contraction of the space in which the appellants have an opportunity to participate. At this point, I really don't think, save for a miracle and the parties coming together and really hearing each other out, I guess, for this to be settled by the April deadline. So I'm seeking clarity on what is the deadline, the general deadline that we're looking at with respect to the implementation.
The general deadline is the date in October that we gave judgment. So, Ms. Duki, I'm not sure of the date, but it's basically October 2025. That would mark the 10th anniversary of the judgment. And that's the date by which we are really hoping the bill can be introduced. I've heard what Mr. Marshall has said. And of course, there are things which are outside of his control, clearly. But we are really relying on him and as well, of course, on Ms. Matut to help us out on this and to use their best endeavors with the government, because 10 years really is enough, I think. It's enough time. And within that window, we obviously want to give the greatest opportunity to the appellants to make sure they have a meaningful participation in the process. Yes?
Chair, the judgment was delivered on the 30th of October.
So we have even more time, Mr. Marshall. Is it almost the last day in October?
I think we can meet that. I think we can give the limitation.
Oh my goodness. This is fabulous. Yeah. Fabulous.
I hope that we meet it with enough opportunity for our participation, Your Honors.
Yes, and that's all our hope, of course. I was hoping you'd have gone a different direction, that you're hoping we'd meet it with time enough to engage in an appropriate celebratory activity. But since you are repeating what you said earlier,
yes.
I'll also repeat what I said earlier, which is that there should be meaningful participation by the appellants, of course. And we have, in a sense, dealt with that in relation to the first item. The second item is the auto-delimitation. I gather, Ms. Mendez, that there has been some progress in relation to the villages conducting this exercise, but that there is a few villages where the mutual boundaries might be an issue. Do you want to sort of lead us off on this and then get a reaction from the government, both in terms of what you say, but also in terms of the embedding of the delimitation process in the policy that was hinted at by Mr. Marshall? Ms. Mendez.
Yes, Your Honor. So in terms of the outer delimitation, our report shows that there is significant progress. We have also been engaging in a completely different process as well that is supposed to support the outer delimitation of surveying and collecting evidence on the different uses. Our position is that the delimitation of the boundaries, what guides that determination is use and occupation by the villages. And so we are engaged in that process where use and occupation overlaps. The villages engage in a process of coming to some agreement, mutual agreement as to where now their neighboring boundaries are. There has been significant progress when it comes to that, but the issue is that if we are unable to come to some agreement with the other side and some clarity on what will be accepted by the other side as to how we determine these boundaries, the communities currently are engaged in a process that might not at the end be validated because what is being proposed in the policy is completely different. So that's something that we've been raising now since the outer delimitation process began. Well, when that was starting to be implemented, whether what was agreed in the DPM will be honored by the respondent. So that's one area. A more specific area now that has arisen, a more specific obstacle rather that has arisen, and where we really need serious engagement from the respondent is the situation where some of the villages, and we don't disagree that each village has the right to decide whether or not they will accept or they will implement their right to their collective and individual rights that are derived from Maya customary land tenure. Some villages currently, however, are undecided. And so that currently the DPM doesn't necessarily give us much clarity as to how can a village that is decided finalize for its own process of setting its boundaries when the other community is undecided. And we have been trying to get clarity, just some process that will be validated by the respondent to give security to the community that has engaged in the process, that has consented to outer delimitation, and has, in many instances, Your Honors, it's most of their boundaries are already set in place, but it's the neighboring community. We have one where it's all of the boundaries, that's San Miguel, all of the boundaries, they have their boundaries set. And when I say boundaries set, Your Honors, for their purposes, their outer delimitation exercise, as well as just the historical boundaries that have been recognized. But in order to finalize the process, you would need some sort of agreement with your neighbors who are also Maya communities for you to then finalize it. They are undecided. So what can the parties now agree will now be the mechanism that enables the decided community to continue. I hope that has been clear, Your Honor. Thank you.
Yes, it is. Yes, thank you. Mr. Marshall?
Yes. Your Honors, the policy sketches a broad outline of how we expect self-delimitation and demarcation to occur. We have never considered ourselves bound by the DPM, which is a draft document that's unsigned. But the activities that have been undertaken on that process will be relevant and useful in furthering self-delimitation and demarcation as contemplated by draft legislation. And I can outline for my friend what it is in general terms without having to disclose too much details. What it is that there is automatic recognition of a certain area in and around each village. So in respect of that area, there's no need for verification of anything. It's whether or not the village members are agreed amongst themselves as to that area. So what is required is a 75% vote by the village members in meeting, approving the application in respect of that area. And there's automatic recognition for that area once it falls within the prescribed, the outer limits, the outer boundaries of it. Because there is a maximum area in which this automatic recognition is to take place. Apart from the area that will be automatically recognized, and application can be made, it's contemplated as well on the strength of a sketch, and government assumes the obligation of doing a survey for the automatic areas. Now, when you're going beyond the automatic areas, you're going to have to prove the 30 years use, continuous use and possession. And you're going to have to supply a survey of the area that you claim is subject to your use and possession. And that onus will be on the village.
Yes.
So that is how we expect these boundaries to be set. So
But
you
can
get
I-
to self-determine what the boundaries are within the area of the automatic recognition. And when you go beyond that, then there's the requirement of proof. And the reason for that is simple, Your Honor. All the third-party titles within the area to be automatically recognized will be automatically extinguished. So there's a need for compensation, and that comes at a cost. Outside that, providing use and possession can be proved. It limits, for the requisite period, it limits the compensation to the third parties outside that, given that their rights would have been compromised by adverse possession in any event.
Yes. What I wanted to ask is, if you were to apply that sort of automatic recognition around the villages, would that cause any overlaps at all in relation to the villages? Your formula?
Yes, it might. And there's a provision. We suggested how we're going to deal with overlaps, and it's along the lines my friend just outlined. The affected villages must agree to the use of the overlapping area. And unless and until there is such an agreement, that space is to be titled to nobody. And that is to create a motivation to come to agreement regarding that space. Because if you can't agree between you as to how it's to be used, then nobody gets it.
Yes, I follow that.
That's the approach we've taken.
And then the radius of the automatically recognized boundary, is that by reference to the formula you had given us before about the population issues?
Yes, but the expression of it is different, because the notion of so many acres per head gives a wrong impression and gives rise to confusion. So what we're saying is that the space must be of a maximum acreage, and that maximum acreage is calculated in this fashion, so that it's understood that that area goes to the benefit of the whole village communally, and it's not that everybody in the village is getting this space.
Yes.
Which I think is the confusion, that the way it was expressed, it caused some confusion, and it was clear that we wanted to avoid that confusion, so it was reformulated. But the effect of it, the gist of it remains the same.
Yes. And the last time we had discussed the issue of the involvement of, international jurists who have experience in terms of delimitation of traditional land areas. In coming up with or confirming that formula, did you have any such discussions?
No, Your Honor, but a part of the technical review that I contemplate is, nailing down some of that in a more precise way.
Yeah.
But the concept is fairly set, and that there will be a space that's automatically recognized. It should be an adequate space enough to sustain life and these villages in perpetuity into the future. That way you go beyond whatever that space is, however it's assessed, there will have to be proof showing some of the same things we're used to seeing when you claim adverse possession.
How did you come up with that formula, though? I must ask you.
It's a compromise between the two approaches of the two sides, where I think the expectation under the old delimitation methodology is that they get to say what the boundaries are, and whatever they say, so long as we verify the boundaries, it must be titled automatically to some extent. And the notion that no third-party titles can't be displaced so easily, that you will have to demonstrate some long-standing use and possession of a space before it's recognized. But the compromise is also a recognition that these villages have a right to self-determination, and we want to preserve a space, guarantee a space for those rights to be exercised. It's where we get into the spaces over and beyond what we think is required for that.
Yes.
You get complications.
Yes.
So those will all have to be resolved. And so we've kind of separated it out so that you can get right away to some space.
Yes. Now we follow you completely. I was just thinking, I'm sure there is a critique to be made of it, but it sounds to me to be one logical way of proceeding. And I was just wondering whether it was unique to Belize that you have come up with this, because if it is, you might want to assert some intellectual property rights over that kind of formula. But Ms. Mendez, in a sense, that would solve some of the problems that you have raised in terms of one village going along with the kind of self or auto delimitation, and then finding that there are internecine issues with villages which are nearby. So that would help you on that front. But I gather you may have other problems on other fronts. So do you have a response? I suspect we're not going to be able to resolve substantive issues here, but at least we have a sense as to the contours of the problem. What say you?
Yes, Your Honors. I don't think it necessarily helps us to get clarity, because if it does help us to get clarity, what it really means is that the efforts that the communities have been engaging in when it comes to setting out their boundaries, when it comes to having intense negotiation with their neighbors, all of these agreements that have really been born out of that process, and I think it's about 5 years, 6 years efforts, they're not necessarily relevant anymore, because now there's an automatic recognition of a particular area, and it might overlap, and now there's another way in which we will deal with perhaps disputes that engage communities.
But even in relation to those disputes, even in relation to those disputes that engage communities, as you put it, the talking, the conversations, the negotiations which have been going on, wouldn't that still be helpful in trying to decide on the mutual use of areas which have overlapped?
Well, that's yet to be determined, Your Honor. To be quite honest,
exactly.
The efforts that have been made on the ground have been tremendous. Precisely. And I will endeavor at the next compliance report to really provide a bit even more information as to what exactly has happened. And I do think that it threatens the fruits of that labor. But until
we decide the tension, if there is any, between the two approaches, isn't it a bit premature to say it threatens the fruit of the labor? Because it may very well be that it provides a basis on which there is an easier route to an agreement in the areas of overlap. I mean, the other thing that is interesting is, have you done any kind of comparison with the actual empirical result of taking the approach the government is proposing as opposed to the auto delimitation exercise you have, right?
Yes, Your Honor. Well, with respect to the first proposal, I'm not too sure what the radius is now, and my learned senior has said that there has been some changes there, but I can only react to the information that I have currently, Your Honors. And I don't think it's premature in the sense that, of course, we don't know, but just in theory, I do think that it might threaten, if I might say so. There's a possibility that it does threaten that effort. But on a more perhaps on a more substantive point, Your Honor, my reaction, and I think it's something that we have already sort of said, and perhaps I can frame it in this way now, that I think to some extent, if the outer delimitation and the demarcation process in and of itself is not really grounded on use and occupation and the ways in which the patterns of use are set out, and rather are predetermined by a calculation, Your Honor, I think then we're not necessarily abiding by the spirit of the consent order, and perhaps even by the terms of the consent
No,
order.
no.
This is
Again,
not,
again,
but
not. Sorry, Council, not to interrupt you. I'm sorry, but just to make sure, I'm not sure that is what the other side is saying. The other side is saying that you have an automatic boundary, and it can be extended beyond that line by virtue of proving use and occupation. Am I right, Mr. Marshall?
Yes, Your Honor. That's
Yeah.
exactly.
Yes, Your Honor, but might I just finalize my thought, Your Honor? I was going to explain why I say that. Might I, Your Honor? I see you.
Please,
Your
yes,
Honor,
no, please.
yes.
I'm sorry, no, please.
As the standards have set out, and as we understand it, and I don't want to get too much, as Your Honor has mentioned, it's not that we're gonna resolve it, but let me just put in a nutshell at least some of the things that jump out. At this point, it's not necessarily, I think it's an erroneous approach to say that right now what we are engaging in is now a manner in which we are now putting the burden once again on the communities for them to prove use and occupation. The idea and the international guidance, as I understand it, Your Honor, is that both sides, together with the government, engage in an identification process. The idea is not an adjudicative process, which I think is what is now being proposed for the mechanism regarding the extended area. It is mostly an identification process, Your Honor. So currently, I think that what is being proposed now is to burden the communities again to adhere to some sort of burden of proof when it comes to use and occupation. And that is what we take some issue with. If it, as I mentioned earlier, yes, we appreciate that. What we are talking about is a right that is born out of long-standing use and occupation. And on its face, it doesn't appear to be necessarily illogical or unfair to put a 30-year limit. But, Your Honor, the problem with that is that there is another criteria, which is the undisturbed, because we are making it, we are influenced by adverse possession. But Your Honor, I think that is conflating third-party interests and how we resolve third-party interests and what are the principles that should guide us in recognizing where my customary land tenure is. And for us, at least, those two things are separate. So disturbances or third-party interests should not be used to then disinherit a community from lands that they have used and occupied. So that's the conversation that we have been at pains of really engaging with my learned friends to see how can we come up with a threshold that gives some clarity, of course, for us to know what exactly it is that we're doing, as well as ensuring that we still meet the substantive nature of the exercise that we are involved in.
Thank you. That's very, very clear. And if I heard Mr. Marshall correctly, I think he did say that that kind of work would be taken into account at the point at which the policy is being finalized, but more particularly in relation to the legislation. But I take your point fully, Council, and look forward to that point of view being pressed in the review committee, if not before, and that due consideration be given to it in the drafting going forward. Thank you for making that very clear. Appreciate it. All right. I'd like then to move on to the next set of issues dealing with the protocol. I think there are three of them. One is the Santa Ana Village project. Now, can we take it that has been resolved satisfactorily? I think the last communications I saw suggested, Ms. Mendez, that you are pleased. We like when you are pleased, and we thought that you were pleased with the final results there. And likewise, I think Mr. Marshall, who hardly smiles, was smiling in relation to that matter. So can we agree that that matter has been resolved satisfactorily in accordance with the FPIC? Ms. Mendez?
This is the Santa Ana, Your Honor.
Yes, ma'am.
Yes, Your Honor, and the signing ceremony and the final decision is set for Sunday, Your Honor. So after much work, yes, we are at a satisfactory point.
Excellent. And we take no exception that we were not invited to the signing ceremony. Mr. Marshallek, do you have anything to say on this, sir?
No, that is precisely what I was told. Message just now that it's all resolved. It's to be signed on Sunday. Santa Ana is sorted out.
Does that date hold any significance in the Mayan calendar? It's a pity, right? It would be nice, but at least small steps, baby steps, Ms. Mendez. Yes. Okay, so we go on to a slightly more contentious matter, the FOB, the Forward Operating Base. Who wants to start with that one?
If I may, Your Honor.
Yes.
The National Security Council invoked the exception to FPIC in relation to establishment of that base.
Yes, and there is. Yeah, go ahead, please. Sorry.
And they explained to me in general terms why they needed to do it. I don't think it would be appropriate to share that.
Yes.
But what I can say is that there are activities going on in the area of that village, of which there's that needs to be dealt with. And unfortunately, village members are involved with it.
Yes.
So it's not that you could go consult with them as to how to deal with it.
Yes, yes. Ms. Mendez, I think you'd agree that the FPIC does have a carve-out for activities involving national security, and that is what is being alleged here. I think the relevant article is Article 3, Paragraph 2 of the FPIC. Right. So, any reactions?
Yes, Your Honor. And at the meeting, and I believe I indicated in the report as well. I note that my learned senior indicated to some extent that there are some activities and the community members might be. I cannot speak to that, Your Honor. What I can say, however, is that at that meeting, the community members and its leaders were very clear. In principle, it's not that they are resisting this base. They also accepted that they appreciate that there is a need to especially patrol the borders, an activity that they play a significant role in fact, in providing information and working together with the Belize Defense Force. The issue is not necessarily one where they're saying you have to seek our complete consent. That is where the carve-out comes in, that consent is not required. But that does not mean that notification and basic information should not be given to the community. So perhaps a curtailed consultative process is what the community is requesting. And why do I say that, Your Honors? Because currently the community has been informed that there's a particular area of land that has been acquired. We're not too sure what that means, but they say that the government has acquired this land. The community doesn't know, they were not given the location of that land. They were not given the location of the land, but yet they were instructed that they are to cease all activities over that area of land, and they have no information as to where the land is. And so, Your Honor, there's also some cultural sensitivities that I also think that the communities want to have a say in, if it is that you're going to decide that this is the area that is going to now be acquired, and that's where the interagency base is going to be. Finally, yes. Finally, Your Honor, I just want to make one last point. Even as we accept that there's absolutely a need to man our borders, there is absolutely a right and an authority and a wide breadth that the Belize Defense Force and that the state has to make these types of national security decisions. The history of the Belize Defense Force as well in the communities is not one that is completely a positive one. It is a mixed one, Your Honor. And there have been incidents of communities making complaints with respect to the relationship that the BDF now has with the communities and in some instances with the women. In fact, one of the first instances that I became involved with here was one like that. So I only mentioned that to emphasize the need to at least have a curtailed consultative process. The community is just asking for information, and of course, information under the understanding that not everything can be provided. There is some information that will have to be withheld on the basis of national security. That was never the issue. We had the first meeting with respect to this base, Your Honor, in 2021. So this was also not unforeseen. These conversations could have been happening with the community since then.
Yes. Could I just say that we could perhaps have a look at Article 3.2, but I think it refers to consultation, not consent. In other words, that the carve-out relates to consultation. I don't know whether you wish to confirm that or not.
Your Honor.
Yes.
No, Your Honor. Right. Again, I don't know that it will get to us to a substantive, and I don't want it to kind of approximate legal submissions. But even if that's the case, Your Honor, any exception to rights must be proportionate. You should only be able to do it so far as it's necessary for you to get the legitimate aim. And all that I'm saying is that in this situation, if we listen to the concerns that the communities have raised, and also the workability of what my learned or what the respondent rather has requested of the communities, meaning you are to seize activities over that area of land. They should know which is the area of land. Where is the location at the at basic. So I just say that to emphasize that for two different reasons, the communities have legitimate concerns and they want to be able to air it out. And two, the workability of what they've been asked to do now also warrants that information be shared to them.
Okay, so two things. One is I think we are clear that the FPIC basically gives a carve out even in respect of consultation. That is what it says. But on the other hand, I think reasonable people would take your view that the priority remains, of course, the integrity of the security operation being carried out, and that is paramount. But subject to that the sensitivities of the community obviously, must be taken into account, and that the members of the community obviously must be treated with the dignity and respect that they deserve, and which we would imagine that the BDF would exhibit. I'm sure that to the extent that he is able, Mr. Marshall would convey those sentiments to law enforcement and to the military. Did you wish to comment, Mr. Marshall?
Yes, John. I just want to make clear, because my friend's suggesting that you don't know where the land is. The land was acquired from a private landowner of long standing. We're talking decades. They've owned this piece of land, and it was bought for them for the purpose of building a base. So I don't know that it involves any activities in the village. And I'm not sure why the admonition was given that is being focused on, because I don't think that is an issue.
Okay, but we bear in mind, I think, the points which have been made. Yes, and I think obviously both.
Yes, we did. I've seen letters, which is not before you in the compliance report, informing the village that the base will be located there and that the exception is being invoked. I do remember seeing it some months ago.
Yes.
So I think we can talk about. So there has been some communication with the village.
Yes.
What there hasn't been is a provision of the level of detail that I think the village members want in order to engage on it. And that is where the rub is. Yes.
Miss Mendes?
Yes, Your Honor. I think we did provide one of the letter that was sent by the director of Indigenous Peoples Affairs. So the issue has not been that the community has been given no information. The issue has been here that they just want a space to be able to engage in a discussion, even if we don't want to say consultation, Your Honors. And that's what they requested. They have been told that land has been acquired, but they were not told the location of the land. And at the meeting that I attended, where this was presented to the community asked for the location. So where is this land? You're telling me that I should not go in there, but you're not telling me where exactly it is. And the response was that that information cannot be provided to the community at the time. My information currently is that it still has not been provided. So just for it not to, I don't want it to be I don't want to be misunderstood. It's not that the community wasn't told anything and we just discovered it. No, there was an engagement with the community, but for the purpose of giving them these details alone. And the community then has certain questions and concerns. That's all.
Okay, I think we're on the same page. So going forward, then the government will use its best efforts, Mr. Marshallek and co-counsel, to encourage the government, if courage is the right word, I'm not sure, to use its best endeavors to communicate as fully with the members of the community as is consistent with the integrity of the operation that is being conducted. I presume there's a liaison officer with the BDF or a public relations officer or community officer, and it would be good if that person, again, without compromising the integrity of the operations, would involve the members of the community, and we expect that that would be the case going forward. We'll move on to the last item then under the protocol issue, the Golden Stream incident. I'm not quite sure what is happening there. One of the questions raised by us as we were thinking about this was the issue of the authority and whether the authority was available to have had a first bite at this. But who wants to go on this one and let us know what the issue is, what the problem is, if there's one?
Yes, Your Honor. Might I go first?
Yes, please. Yes.
I do want to flag to the court that we now do have instructions to utilize the authority. What I had advised the village is that initially what we should do is that before we go to the authority and for it to get to that level, we should communicate with the relevant authorities so that they have an opportunity to really address it without having to present that complaint. So that is why we started off by sending a letter to the director. But based on the response that we got, and if I might say a bit of a caustic response, I think, if I might say so with all due respect, I think we will have to go to the authority. The issue is this, Your Honor, might I succinctly put it. The village members, the village leaders, saw, observed, unrecognized, unidentified persons in lands that they use and occupied, in lands that they claim. After that, it's when they discovered one of them, Mr. Hernandez, indicated that they have title to the land. So what needs to be done first is to appreciate or verify whether this title has been validly granted. What is this title? Our understanding is that the scope of the consent order includes an injunction, rather, it has an injunctive effect against the registration of any interest in land currently, but also in preventing any activities that might adversely affect the use and enjoyment of lands that are claimed and used by the communities. So I understand the consent order to be broader in scope. And of course, my learned senior is here, but it appears that we are not at the same, we don't have the same interpretation of that consent order, and what the community was really seeking to get help, get assistance from the Office of Indigenous Peoples Affairs here was to get some help in information and some assistance in de-escalating a potentially disturbance of the peace, Your Honor, because now we have two people claiming this, two entities, well, the village and the private person claiming an area, and there might now be a confrontation. So we wanted to get assistance in that respect. We have serious concerns about the title itself, Your Honor. We were hoping that we could get some information, but as I mentioned, we did not, the response from the respondents do not offer much information. But since then, we have real reasons to believe, Your Honors, that the purported transfer of this title is not a valid one. When we look at, we've been able to get some information from Lands Department, Your Honor, and it really does appear that there's real reason to believe that the purported transfer is in fact a dead person. And so we wanted information or assistance from the respondents for us to settle and for us to know where the community stands with respect to this area.
Yeah, thank you. I think we have given you a little latitude there to bring in some evidence which may properly be placed before the authority. And you did say that you are now going the route of the authority. And I think that might be a good way to suspend further discussions of this. I don't know whether Mr. Marshallek would want to say anything.
Your Honor, I think we agree to disagree on this. And the issue is whether or not the consent order on EPIC binds third-party landowners and the extent to which it does so. Because there isn't any complaint about anything the government did in this instance. There was no registration, there was no permitting, no license for the activity. You have a landowner purporting to act under by virtue of his rights, his existing rights over land. And the point that we tried to make is that, look, if that is what is happening, there's nothing that can be done about it. But if it is that he is in his activities infringing on regulations governing the environment, land clearing, then certainly we can't give permission for that unless and until there's a consent. So the process, as I understand it, is that if there's application for the permission, the consent is made a condition of permission being given, and that way it's drawn in and imposed on the third party. But what was sought to be done here is to impose directly on the third party these terms, which they have no relationship to.
Yes, I want to be very careful because, as you say, this is a potentially a legal matter which may come up again. But I would remind you, Mr. Marshallek, that paragraph 4 of the consent order requires the government to do certain things. Cease. One brief second, please. No, thank you. Yeah, sorry. That's the housekeeping at my hotel. Yes. I don't know if you've seen paragraph 4, but it invites the government.
I'm looking at it.
Correct. And it also extends that obligation in relation to certain activities of third parties, acting with the tolerance of the government and so on. So if you have a situation,
yes.
Correct. So the consent order does place some obligation on the government to monitor, supervise even the activities of third parties. It may be that that's done through the mechanism of the approval process, for example, but surely if somebody goes on land to clear it, then that is development, isn't it? That comes with the definition of development. And you can't develop land without permission. And to get that permission, then I think the terms of this consent order would want to then draw in the obligations of consent and consultation and so on. Wouldn't you agree?
Yes. The complication is where the person who's undertaking the activity holds a title of long-standing that is not disputed.
Right.
That authorizes the activity in which he's engaged. So that if it's lawful activity that's being engaged in upon the land, how does the government act to prevent it without interfering with the constitutional rights of that third party?
Yes, but even if the land is lawfully the person's, that person, I'm asking you because I'm not an expert in the laws in Belize, that person cannot engage in the development of that land without permission, can he or she?
Correct. No, he can't build anything on it. Even the land clearing activities.
Exactly. Exactly.
And
so
that's what we can't give the permission without consent, and we haven't given any.
Right. So that might be the way to approach it. And, you know, therefore, to suggest that the consent order is not binding on the third party is correct, you know, but it's not the full story because the government has obligations there which relate to controlling the activities of the third party. Yeah.
Yes, Your Honor. And we accept that. There's no dispute that. Even in relation to the seismic testing and Santana that we're signing, it was the government saying we can't give permission for this to be done unless you have consent.
Yes.
And that's what starts the process. But Mr. Hernandez didn't come for any permission to do anything.
Well, if he doesn't come for permission to do anything, then other people might have to come to him for other reasons. Because he has to get, he has to get permission to engage in development. And if a citizen thinks that the law is being broken, then they have every right to bring their allegation to the attention of the relevant authorities, which I guess is what the Mayan people are doing here. Yes. So in any event, I think we can draw a line here because the matter now is in the hands of the authority, and let's see what happens from this point. Thank you very much.
Chair, if I may, Mr. Marshall, you're not suggesting to us that the government could do nothing.
No.
No, I would hope not. Yes.
I was suggesting that the correct way to deal with it is through his application for the permit to clear. Because when that comes to the government says, well, you can't get any permission unless you go to and get the consent of the village. Then he knows the legal basis upon which he needs that consent. But what happened here is just an indication directly to him that he needs to go to the village for consent. And of course, he doesn't understand why he would need to go to the village for consent.
You know, and a letter written
that conflict.
Yes, a letter written in the very eloquent terms you just espoused might have saved a trip to the authority. I don't know, but I'll leave it up to you.
Okay.
Okay. All right. So I think we're finished with those three items. There was an item on the Inter-American Commission on Human Rights, and of course we respect that organization as an important body which plays an important role in promoting human rights within our hemisphere. But I would just caution Ms. Mendez that we are not purporting to exercise any kind of jurisdiction, we don't have any, over the obligations of the Government of Belize to the IACHR. So that I am a little wary of getting involved in any kind of dispute about the extent to which the government is or is not discharging its obligations towards that body. As you know, we have invited them to attend these hearings. We, I think, committed to, correct me if I'm wrong, Chelsea, but I think we have committed to sharing even, and I think the government would have approved of this, reports which come into us with them. But I would respectfully ask that we don't go into a discussion which involves any question to do with compliance by Belize with their obligations to the Commission for the reason I tried to set out to. Would that be okay?
Okay.
Certainly, Your Honor.
We were
Yes, you want to go first, please?
There's a little delay. Sorry, Your Honor. I think I can clear this up very quickly because I think there's a fundamental misunderstanding of what happened here. And the way it's been characterized is not quite correct. One, the Ministry of Foreign Affairs hosted the Commission on its visit and traveled and made sure they were comfortable and their needs were met. So the people from the government who attended the meeting were those people. That's clear. The Commission had informed us that they wanted a meeting on the 15th, and they were informed that the parties with whom they wanted to meet were not available on the 15th. There was a conflict. And that meeting was rescheduled by the Commission to the 16th. And we did meet with the Commission on the 16th. The policy as revised was shared with them. Everything was discussed and everything left. We're very cordial with the Commission. They're fine. So I don't know why there's this suggestion that the government somehow blew off the visit and ignored them, because that is simply not the case. And I also don't know where the notion of there was to be some working session comes from, because when it was indicated to the Commission that the 15th, the peer parties were not available, they suggested the 16th, and the meeting was held in Belmopan. I attended the meeting. It was very cordial. Everything went as planned. I'm not sure where these allegations come from. They're not coming from the Commission.
Mendez?
Your Honor had signaled that there was a hesitation of getting into it, so I honestly would not want to get into too much detail, except to say that I disagree. And at the last hearing of this court, there was an indication that a particular form of meeting would take place, at which time we would discuss. I only included it in there because of that, Your Honors, and because we have been keeping the court just updated as to general meetings. And in our view was just an example of non-engagement that we started off our hearing here today, as well as an example as well of the lack of communication between the parties, which I do think it was relevant, but it was not an intention for the court to make any orders or anything, any commentary on what the purpose and role of the Commission itself is. So just to clarify that it was information sharing in that sense, but I won't get into anything else.
Yes, I appreciate that very much. And we obviously are interested to know that, you know, you're meeting with the Commission. That is useful. And as I said, we have invited them to be observers at these hearings if they so choose. All right. So the last thing then would be the revised roadmap. I know things are fluid, and we discussed the timetable a little earlier. I don't know if there's anything further you can add to what you said earlier, Mr. Marshallek, in terms of getting us to safe harbor in time for the 30th of October, or yes, where are we? Yeah.
All I can do is to offer to set out the very timetable we discussed in a revised roadmap and to send it to the other side for approval and to have it filed, just to record it. That's the intention at this stage.
Okay.
Okay. But we do have a very clear schedule, and as of May 5th, then the roadmap as previously set out in the existing document continues, and we use those same time frames going forward.
Yes. I'm terrified to ask you whether you have any ideas to when there might be elections in Belize. But I suspect you have not, your role has not changed from what you are to the Prime Minister, so you would not have that information, would you?
No, there's lots of speculation on that, and I wouldn't want to add
You
that.
wouldn't want to add speculation, okay. Yeah. That feeds into the other question, though, as to when next we might meet with Profit. Wow. The review committee ought to get the documents by the 4th of May. Would sometime after May be a good time to see what progress has been made? Or is that too far? Any suggestions?
I think it's both. It's a logical time, but it is a little far. I think maybe we can check on the status of things April to make sure the approvals are had and the papers go forward to the draft first.
Okay. Ms. Mendez?
Yes, Your Honors. I think from our side, we would want it to be a little closer in time, perhaps the first week of April. That's at all possible.
First week of April. We are hoping, based on the hope of Mr. Marshallek, that there will be an event around about the 4th of April it would be nice to meet runabout then. So yes. Any particular date? The first week in April?
I was going to say the 3rd, but the 10th of April.
10th of April.
Still a Thursday, Your Honors.
Why do I think something is happening on the 10th of April? Ms. Dookie, do we have a judicial commitment on the 10th of April?
No, please, Judge, I don't see one on my calendar. Could registry just confirm, please? Clear, it's a clear day.
It's a clear day. Okay, good. All right. At the usual time?
Yes.
10 o'clock Belize time, 11 o'clock Trinidad time?
Yes, Your Honor.
Chair, just a request on my end. It would be ideal if we could schedule it before the 9th, if possible.
Before the 9th. Okay.
The 8th?
8th, I think we have a matter.
We have a matter, but the 7th, yes, the 7th is up. Could we see if the 7th is a possibility? That's the Monday.
The 7th? 7th.
Mr. Marshall?
The 7th works for us.
Okay. Mr. Hughes?
It does, Your Honor.
Chelsea, it works for the court?
Yes, please, Judge.
Thank you.
Okay, so we will set the next monitoring hearing for the 7th of April at 11 o'clock Trinidad and Tobago time. We would normally get the compliance reports in a couple of weeks before that.
Usually 2 weeks, Your Honor.
Sorry, in this case, Your Honor, because the delivery is to be April 4th,
Yes.
I want to be able to say in that report whether or not that has taken place.
Yes.
So I would want to suggest maybe the 5th. Or that's a Saturday. The Friday the 4th. Just so that you can have something useful to report. Hopefully.
Yes. Ms. Mendez?
Your Honor, that works. Or another approach could be that we file a compliance report 2 weeks before and a supplemental one just to update the court on the development and whether the 4th of April timeline was met. Of course, up to the courts. It really depends on how much the court needs to really review the compliance reports, Your Honor, since we would be before the court on a Monday.
Yeah. That would be very little time, Ms. Mendez and Mr. Marshall. We would be getting the reports on Friday the 4th and hearing you on the 7th.
Yeah.
Right, Your Honor.
It's
so
just
the
a weekend.
Indeed, Your Honor. So the suggestion is that on all the other matters, we would have already provided a report and updated the court on those matters. But perhaps on the 4th, it would just be to update the court on that specific task or that specific action plan. That was the suggestion, Madam Justice.
That's fine with us. That works.
Okay, great. Ms. Dookie, you got that?
Yes, Judge.
Okay, wonderful. All right. Is there anything further?
No, Your Honor. Thank you.
Thank you so much. Well, thank you again. And we will see you again, all being well, on the date indicated. Madam Deputy Registrar, would you mind bringing the proceedings to a close?
Thank you, Mr. Justice Anderson. Thank you, Madam Justice Rochnatli. Thank you, Madam Justice Ononiwu. Thank you, Counsel. And thank you to the staff of the Caribbean Court of Justice. This court now stands adjourned. Good day to all. Thank you.
Thank
you
you
very
again.
much.
Bye.